All right, welcome everybody to this special bonus live piping in all across the cyber world with the one and only Brian Ponder Esquire, and of course yours truly, Stephen Palmieri. Except that we're piping in Brian's channel, so they may not know who I am either. Look at that. We're trying out a new feature where we're piping in all over. Brian, what's going on, man? How have you been doing? Long time.
Steven, doing great. Super busy these days.
You're the FDCPA slayer, man. We are going to get into all sorts of good stuff here, but Brian and I connected like 30 seconds ago, and I was like, we can catch up live or we can catch up in private. So we were like, let's just catch up live. So let's catch up live, Brian. So what is going on new in your world, man? I mean, you're still doing FDCPA. Is that your sweet spot? What have you been focusing on?
Yeah, a lot of my consumer cases involve the FDCPA and the FCRA. I would say that's the majority of the credit related cases. Absolutely.
So are you seeing, obviously the FDCPA, they had those regulations that came into place like a year and a half or maybe almost 2 years ago now. Have you seen that that's a game changer as far as it pulling in all the social media stuff, how they could communicate? Or for you, is it just kind of like business as usual? I mean, pretty much they're nefarious. You trap them in. It doesn't really matter what the regulators say.
I thought that Regulation F was a sort of a game changer, but I haven't seen a lot of issues come up with violations there. And I guess it's because they're violating so many other places. It's like you just taking the low hanging fruit. So I haven't yet had to reach to that. And interestingly, I haven't had a lot of people, dealing with some of the social media messages.
Oh, you said, yes, what I like about you, Brian, is you're just so cool and stuff. But you said they violate in so many different places, like it's just a low-hanging fruit. So let's talk about that. So what are some of the low-hanging fruit, egregious things that you're seeing that aren't even gotchas? It's just literally like, dude, just open up your checkbook, guys, because you guys know you did wrong.
Sure. Well, some of the low-hanging fruit when it comes to debt collections would be the debt collectors trying to collect the wrong amount, adding fees. Another violation is the debt collect. A lot of consumers now are familiar with how to dispute debt collection, so we see a lot of violations where the debt collector fails to mark these debts disputed on the consumer reporting side. And we see a lot of violations where the consumers are requesting a verification or validation of the debt under 1692 GB, and the debt collector is not fulfilling that request. More so, they're not ceasing and desisting collection up until they fulfill that request. So those are some basic violations. And if they did fulfill the request, you see they're collecting on something that's not provided for, like an amount that's not provided for by an agreement. So that's like a 1692 F1 type violation. So those are the low hanging fruit.
I'm going to call you Mr. GB. In fact, I've already called you Mr. GB throughout my Facebook experience. That's your MO right there. But you really do. I see Vance is watching. He said, "We live, baby." He's got his I Sue debt collector shirt. You need a shirt that says, "I'm Mr. GB." The OGB. All right. So anyway, we digress, but let's get focused here. So actually, GB, let's talk about that. And we were chatting about that in Facebook the other day. And so it's been it's always been the age-old issue of, is credit reporting considered a debt collection activity? And I guess under FCRA it had gone back and forth, and then you were like, Stephen, here's this precedent, like basically where we are today. Under FDCPA, credit reporting is considered a debt collection activity. You were saying that's basically the current precedent interpretation under the FDCPA of credit reporting. Is that correct?
Yeah, there's case law that takes that position. And sure, at different circuits meaning different blocks of federal courts, may not have a necessary, that decision is in one place, or at least one place that I provided.
Yeah.
And so what that means is it's certainly the precedent in that circuit. And I forget, I posted the case, and I'll repost that case in the comment section, where it does say that, consumer reporting of a collection is a form of debt collection, which makes sense because you're trying to.
Yeah, I mean, it does make sense. I mean, why the hell else would they report? Especially if they're debt collectors. It's not like they're part of a credit origination system where they actually need to be able to pull credit reports and assess new clients' credit worthiness. Like Capital One reports credit because they need to pull credit, because they need to assess risk. Portfolio recovery doesn't need to assess risk, right? They're not originating credit. They're literally just buying bad debt anyway. But why this is important is because under GB, and I want us to talk about GB for a little bit here because it's often misunderstood. So 1692 GB is where it says in the FDCPA that if you were to dispute in writing during the first 30 days of when they send you that first 30-day notice.
Right.
Jesus Christ. Let me get my words correct here, Brian. When they send you first notice, then you have 30 days to dispute in writing. That's what I'm trying to say. The validity of the debt. And then what's supposed to happen there, they're supposed to cease collection activities, right? Which is where this whole credit reporting isn't a collection activity until they validate the debt. Now, gosh, there's a whole lot of ways we can go with this. So number one is, I think it's a common misunderstanding. People think they have 30 days to respond, but they actually don't have to respond. That's right. Which is why the law was written, where it's like, hey, if you dispute it in the first 30 days, there's these actions that are supposed to occur. They're supposed to cease collection until they do their part, which is, verify it, which under the language of the law is not really very strong, validation. It's like, okay, get a copy of the judgment or, name of the creditor. Mm-hmm. But obviously where you sit with precedent and all that, we can get into that. But so it's true that if you dispute it during that first 30-day window and you don't hear back from them, they technically can just hang out there forever as long as they're not collecting. They have no duty to respond as long as they're not collecting. Is that fair to say, Brian?
That's correct. Yes, that's correct.
So now this is where that whole credit reporting, at least under one circuit, being interpreted under FDCPA as debt collection comes in, because if you send in that dispute in writing during that first 30 days, well, I guess they're supposed to temporarily delete the reporting. I mean, is that kind of how this all ties together?
Right. So it ties together. And by the way, 15 USC 1692 GB, I think, is one of the most powerful FDCPA sections that a consumer can use to deal with debt collection. That's my go-to recommendation for everyone to really hit a debt collector with a GB letter. But correct. So the GB says that the debt collector must cease and desist all their collection efforts until they provide the verification. And if they decide not to provide the verification, then they can cease and desist collection indefinitely. And in my position is because of that court opinion, that includes consumer reporting. So it's not just dunning letters and calls, but that also means you need to delete the consumer reporting. And in my letter, I specified that, they have to cease and desist collection, including, deleting any consumer reporting until the verification is provided.
All right, now let's get good and juicy here. So when I was a young little grasshopper reading FDCPA, I was disappointed when I read 1692 GB because I was like, oh, it's only good for the first 30 days, which is what GB is. But there's some precedent. I don't know the case, but for 2 or 3 years ago or something, Brian, and chime in here, but where basically, the court ruled, and it kind of overturned I think 20 years of how the debt collectors operated. But it said, hey, yes, GB says, well, first of all, GA is the notice. So GA says the debt collector is required to put the consumer on, give them a notice within that certain 5-day period. And then GB says once the consumer gets that notice, they have 30 days. And then, but the framework of the FDCPA, debt collection abusive practices in general is prohibited. It specifically says they can't collect any amount that they are not expressly authorized, either under the contract or under the statute. So this interpretation, this precedent basically says, the consumer can dispute it really at any point in time. Now, the GB provision of their obligation to cease collection is not triggered if you dispute it after that 30-day technically. But if you dispute it after 30 days, for a debt collector to just sit back and be like, oh, well, we don't have to validate it. I mean, they're putting themselves on precarious territory there because they have been put on notice by the consumer that there's a disagreement. And well, they expressly under law can't collect on an amount that they don't have the authority to. So tell me, kind of for our listening, the consumers and the credit repair folks out here listening to this, right? The majority of the consumers that we're going to be coming across are beyond that first 30-day window. And so tell us how you weave those two things together, post 30 days and pre 30 days, and how can our average consumer and average CRO still use the full hammer of the FDCPA at any point in time to help these consumers?
Sure. So you point out some very good distinctions that we can speak about. The difference between disputing and requesting verification or validation from a debt collector. And you're correct. You can dispute at any time. It's not limited to 30 days after you receive the GA notice from the debt collector. You can dispute at any time. However, if your dispute, and by the way, you can dispute without requesting validation or verification. Okay, it's not the same thing. You can send a letter requesting verification and not dispute it. And you can send a dispute within the 30 days and not request validation or verification. And the reason I use those two words is because the section section 1692G, it describes itself as validation of debt, and then in GB it talks about verification. So that's why I use both words. And a lot of people try to say that one or the other. It's not. They're both the same thing. So back to the point, disputes can happen at any time. Validation or verification has to be within that 30-day window of the GA notice. Now, here's another problem. People don't understand what that 30-day notice, within that 30 days, what that means. A lot of people mistakenly think it's within 30 days of an initial communication from a debt collector. That's not necessarily true, because you can have an initial communication from a debt collector that does not have the GA notice in it. So if they call you, or if they write you, if they don't have the GA notice, which are 5 distinct things in it, then the 30-day timer has not yet begun. So keep in mind that just because something's on your credit, has been on your credit for 6 months, the 30 days may not have begun yet. Did you get a GA notice from that debt collector? If not, that clock, that 30 day time has not begun. And here's my little graphic here, a little thing here.
Nice. It has not begun here. I'm trying to pull it up here. Let's go ahead and let's pull this up actually for our viewing audience. Share screen. Let's see here. Window. I'm going to share this screen over here. I've got like screens all over the place. Okay, so this is 1692G. GA has to do with a notice that debt collectors are required to send. So now you had said something really, really important.
Use your finger or your control or command plus, and you can make everything bigger on the words that way.
Do what? Oh yeah, control
you
plus.
Can do, if you're on a Mac, you can do command plus.
There we go. Maybe
a couple more times, it'll be nice. Yep. Oh, nice.
Look at it. Let's see now, Brian, you are a professional liver, aren't you? You know all the tricks here. So let's talk about this. First of all, let's go ahead and unpack. So first you said, well, you can receive communication from them and not receive this notice. That would put them in violation of GA, would it not?
Wait a minute, say it once again.
And now I thought I heard you say a minute ago that they can be in communication with you and not send a GA notice.
Correct. So that would be a violation if they don't send the GA notice within 5 days. Because
Okay, so that's where I wanted to make that point was if. Okay, so because again, we're looking for violations, right? It's important. So they are supposed to send this within the first 5 days of any form of communication, right? Whether it's a phone call, a smoke signal, or they come knocking on your door with a baseball bat. Doesn't matter how they communicate, they're supposed to send you this notice. Is that right, Brian?
That's right. That's right.
Okay.
In writing too.
In writing. So, okay, so within 5 days of the initial communication in connection with the debt, okay, they're supposed to send a notice containing, so they're supposed to notify you, number one, the amount of the debt, number two, the name of the creditor, number three, this is kind of what we've been talking about here, a statement that unless the consumer within 30 days after receipt of the notice disputes the validity of the debt or any portion thereof, the debt will be assumed. So they send you a notice basically telling you indirectly that you can dispute it within 30 days, but directly that if you don't dispute it within 30 days, it'll be assumed to be valid. And then that precedent that I was mentioning, basically they say, yeah, it says this, but just because you don't dispute it and they assume it valid doesn't mean if you dispute it later, they can't say, oh, well, we assumed previously it was valid, so we have no duty in the future when you dispute it to actually validate it, right? So, a statement that if the consumer notifies the debt collector in writing within the 30-day period that the debt or a portion is disputed, so they're notifying you that they're going to verify, the debt. And then a statement that upon a consumer's written request within the 30 days, the debt collector will provide the consumer with the name and address of the original creditor. Okay, so this is a notice that debt collectors are supposed to send to the consumer within 5 days of initial communication. So if your client out there has received the communication or multiples, and well, let's talk about that. My goodness gracious, like rabbit trail. So let's say a debt collector contacts a consumer 10 times and does not send this any one of those 10 times. If that consumer were to find Brian Ponder Esquire, would that be 10 violations of this requirement or just one violation?
Well, I would say one violation. I mean, that GA notice is required within 5 days of the initial communication. So those subsequent, so the violation happened. It's a GA violation, so I don't think that. So
that could happen once. That's kind of what I was thinking.
That's my thing on it.
So then we have the GB here, which is what you're going to get your shirt that says Mr. GB. So disputed debts. If the consumer notifies the debt collector, and I notice this has to be in writing within the 30-day period described above. Remember, above described a notice that the consumer is supposed to receive. Once the consumer receives that notice, if the consumer notifies the debt collector in writing within 30 days that the debt or any portion is disputed, or that the consumer requests the name and address of the original creditor, the debt collector, here you go. So this is why there is no time period. See, a lot of people think that they have to respond in 30 days. This actually doesn't provide a time period for the debt collectors to respond. They just have to cease collection of the debt until they decide that they want to do what they have to do. So they shall cease collection of the debt or any disputed portion thereof. Again, if you dispute a portion thereof, any disputed portion thereof, until the debt collector obtains verification of the debt or a copy of the judgment or name of the original creditor, and it's all mailed to the consumer. So here we go. All right, so let's unpack this. So first of all, the consumer can dispute it in writing within 30 days of receiving that initial notice. Debt collector has as much time in the world as they want, as long as they cease collection, and then they can then resume collection, once they've provided this validation. Okay, so they have 30 days to do that. And let's see here where we're at. Collection activities and communication that do not otherwise violate this chapter may continue during a 30-day period. Okay, so what's an example of, would they be able to, how would there be a collection activity that would not violate this? Would it be like if you dispute a portion of the debt and then they're like, okay, we're going to collect on the undisputed portion? But that's a really dangerous
Exactly. So it's a lot. So GB here that we're reading, we have to really take it line by line because there's a lot of booby traps and mistakes you can make here. But you're correct. So you read above, if the consumer disputes the debt or any portion thereof, then they have to cease and desist collecting that disputed portion. So the takeaway from that is don't dispute a portion of the debt, dispute the debt as a whole, because if you dispute it as a part of it, $5, then they can, if it's $105, then they can continue collecting on the 100 until they, that would be, I think, a loophole. So don't say, I don't owe $105, I owe $100. So you don't want to do that. You want to take the whole package and say, I don't, that whole amount you're trying to collect is wrong. So don't dispute a portion, because that would allow them to continue their collection effort on the undisputed portion.
Just tell them to go pound sand on all accounts, huh? Just say, you guys go take a long walk out into the beach off the shore. All right, let's see here. We've got, again, Vance is giving us, Vance Dotson, the little thing is there, Rockets. How are you, Avante? I can't see what your little emojis are, but we love the emojis. All right. And then Africa NY, shout out to Mr. Ponder. Mr. Ponder, you're Mr. GB. All right. So now let's continue to unpack this thing here. So let's suppose you do have a consumer. By you, I meaning not.
Go back to the first sentence. Pull it down to the first sentence, because there's more that we can tell the audience. All right.
Okay.
So again, where it says portion thereof, so never just dispute the portion, dispute the whole. Another key thing is in writing. Remember, you can dispute at any time. You can also dispute by phone, but if you want to get verification or validation, you have to keep in mind this has to be in writing. I know there are a lot of people online saying, hey, call and request verification. You can't do that. It's not. It may work because the debt collector may want to cover themselves, but a verification request to a debt collector has to be in writing, which could be email, fax, letter, certified mail, in writing. So that's important. Another trick in this GB that a lot of people get caught up on is that, you remember earlier I said you can request verification or validation without disputing. And so the third line where it says is disputed or the consumer requests the name and address of the original creditor. So that or is a very important word because it's either or. So if you dispute, then they have to do verification, or if you ask for the name and address of the original creditor. Now, what you don't want to do is ask for the name and address of the original creditor. And why not? Because they can just write you back and give you what? The name and address of the original creditor, and GB is satisfied. So you want to be careful that your GB letter does not ask them for the name and address of the original creditor, but instead request specific verification documents. So that's something that I've taught my students to be sure to take. Don't ask for the name and address of the original creditor, because it's an easy out for the debt collector to respond with just that. Because if you read down, they have to cease collection of the debt or any disputed portion thereof until the debt collector obtains verification of the debt or a copy of the judgment or the name and address of the original creditor. So those ors are huge because the debt collector can do one or three of those things. They can provide verification documents, copy of the judgment, or the name and address. So don't ask for the name and address, because they could pick up on that and send you that, and their job is done.
Just call up and say, I ain't paying you a thing. Don't ever call me again. That covers it all. It covers a dispute, the cease and desist.
That's a CC. That's a CC thing. That has to be in writing too. So we'll talk about that. So if you call and say, I'm not paying you a thing, it actually doesn't trigger CC. That has to be in writing. But
I feel like I'm caught in a hyperloop, like a circular hyperloop here, because there's so many ways where we can go with this. There's so many ways. So first of all, let's back this thing up. So the word dispute is, this is one thing I talked with Vance Dotson the other day. The dispute is not defined in the FDCPA, right, Brian? The word
it's not defined, but dispute is any challenge to that.
Well,
I don't think that's right. It can be a dispute. That's
I mean, so
threshold.
Yeah, so it's not. I mean, if they had defined what the word dispute is, then the consumer would have to limit that dispute to the defined term. But if it's not, it's up to plain English and case law, right? So they're just saying, hey, look, you can dispute it. So what is a dispute? So first of all, forget about GB. The first 30 days. Let's just talk about what is a dispute. So I were to reach out to a debt collector. I mean, or let's talk about what's not a dispute. I don't even know. Let's talk about it however you want to. So because these debt collectors have to have processes, right? I mean, I feel for them. I mean, we don't like them, but I do feel for them because they are trying to run businesses and, I mean, trying to do the right things, you would imagine. But it's a very difficult thing. Put yourself in a position of these guys, right? Because it's like you've got all these people calling up saying all these things. And I mean, on the one hand, they can have a process that literally says every time I talk to a consumer, market is in dispute. Well, that's probably not a good business process, I guess. I don't know. I mean, if that's not their business process, then they have to kind of like have this decision tree on when do we interpret communication with the consumer as a dispute, right? So let's talk about a dispute in general. First of all, like if somebody were to come to you and say, how would you determine, first of all, if it was a dispute, regardless of whether it's a GB triggered 30-day dispute?
Yeah, I would define a dispute as anything other than agreeing to the debt. So if you disagree or have any question about or the debt as a whole, any portion thereof, then you have a dispute. So if a consumer calls a debt collector and says, I don't think I owe that much, or I thought that was paid, or I thought insurance paid it, or that amount doesn't seem right, that's clearly a dispute. Now, if the consumer calls and says, yeah, I agree that I owe that, but I can't pay it right now, then that's not a dispute. But a dispute, I would say, is anything short of an agreement of the debt. I don't think calling in by itself and just talking to the debt collector is a dispute.
What if you're the consumer, or just the debtor, and you talk to the debt collector and you're like, well, I don't think I owe you because I don't know who you are, but I owe Capital One, but I don't. Who the hell are you? Would that be a valid dispute, or would that be like they just screwed the pooch on that one because they acknowledge that they owe the original creditor?
Yeah, I think I think the debt collector could be in trouble if they don't mark that as a dispute, because again, that's not full agreement. They're disputing who it's owed to or who they should pay. I think that there's a argument that can be made that that's a dispute too, about who should be paid.
Okay, all right. So we've got dispute defined as it's not really defined, but you just got to tell them, hey, I disagree with the amount in general, and that's good enough for Brian. Okay. So then we have first 30 days and we have post 30 days. So let's talk about that. When you're taking an actual case and pleading it, I mean, you're probably not going to know at that point, I would assume, having not actually served them yet and gone through discovery. I mean, you may not know if that was within 30 days of the first communication. So, like, do you plead GB, but then as an alternative, just in general, it was a dispute and all these other parts of FDCPA apply? Like, how do you keep yourself if you claim GB and then a debt collector is like, well, Your Honor, I mean, here's the letter we sent a year ago, so it's not GB, right? How do you first of all cover your bases on that part?
Yeah, usually a case won't be just solely a GA violation. It's usually a F1, which talks about trying to collect an amount that's not provided for by agreement or law, or 1692 E8 with the credit reporting issue. Basically credit reporting an amount that's not that's false. And sometimes we'll put a E2 violation. So all these together typically will find themselves in a complaint, because most of the time, if it's not on the consumer report, then a 1692 E8 won't come into play. But if it's on the consumer report, it'll have E8, usually F1, E2, those things.
Okay, so let's unpack this for our amazing beloved audience, which, by the way, we've got Charlicia Miller,
Mm-hmm.
the GOAT. Now, Charlicia, I don't know if you're saying I'm the GOAT or Brian's
Most likely,
the
you,
GOAT, both
Stephen.
of us. It's got to be both of us, actually.
No,
There we go. All right, very good. I like the confidence, Brian. So let's talk about this. So first of all, Congress could have just written that and it was a good catch-all. Like they were just like, basically, they can't use any unfair or unconscionable means, boom, done. But then they kind of enumerate these certain things that are like, by the way, just to define what unconscionable or unfair is, we've got these enumerators. But let's just talk about this part, right? So if we go back to GB, Charlicia, we think we're funny as well. We love you. Thanks for joining. All right. So again, let's just kind of unpack the language of the law. GB covers the first 30 days, which requires them, if they want to continue, resume collecting to validate, quote unquote. There is no like mechanism to validate after 30 days. Now, so this here says they can't use an unfair method to collect the debt. Now, this you'd mentioned F1. So one says, now this has to do with what governs their actions, not what governs necessarily the debtor's rights per se, right? This says for them, they cannot collect an amount unless the amount is expressly authorized. So here's where I'm trying to go with this, Brian. So if the debt collector has a copy of the contract right there in their office and the collection guy is looking at it, it's pasted up on his wall. So they're like 100% confident. Yeah, we've got the amount, we've got the right to collect this thing. But the consumer disputes, let's just assume it's not a GB dispute, okay? They just disputed at some point in time, and they're like, hey, I think it's unfair what you're doing. I don't recognize this. Please proof it up with my original contract, okay? So let's unpack what this says, as far as this kind of saying, okay, if they're confident that they're legally collecting it, the consumer doesn't necessarily have the right to that proof. I mean, I'm just speaking what I think of this. I'm going to have you chime in. But then the consumer does have the right to not be victimized by unfair practices. So how do you... So if they don't respond, like if the consumer repeatedly disputes it, is like, please provide me some validation of this thing, and they keep collecting, and then they've got the signed contract right here, but they don't send you anything. Is that problematic if somebody like you were to sue them and say, hey, the client asked for some sort of original proof, it's unfair, and they're like, we didn't have to prove anything, Your Honor, but we do have the proof, so we think the debtor should pay our attorney's fees because it was a frivolous suit, because we didn't have to provide them with anything because it was after 30 days, right? How do you weave the unfair and general provision with the collecting that they have to be able to collect expressly authorized with the consumer's desire to actually get proof of it after 30 days? How do you weave that all in together?
Okay, well, like you alluded to, it does take you back to GB. That's why I suggest that anyone dealing with a collection issue start off this process with a good GB letter. Now, not just any GB, but a good GB letter, because that's going to trigger. Ideally, you want to trigger GB, so they have to provide verification. And so now we're back to the part about, well, what if it's beyond 30 days of a GA notice? A lot of people, again, they think it's 30 days of initial communication. Well, my question to a consumer is, when were you first contacted by the debt collector, and did it have the elements of the GA notice? Now, as you can imagine, most consumers may throw away that communication, don't have a copy of it. So we have to go by their recollection. So their recollection may provide that they never heard from that debt collector. So we have to rely on that. Or the recollection may say, yeah, I got a letter from them, but I don't have a copy. Well, now we're in a position where we really don't know if a GA notice was provided over 30 days ago. So my suggestion is to go forward with a GB letter and assume a position favorable to the consumer that no GA notice was provided, because we don't have proof that it was. Now, if you request that verification and it's a proper GB where you're not asking for the name and address of the original creditor, but you're asking for specific verification documents, which would be, because we were looking at F1, an agreement. We want an agreement. And remember, an agreement is signed by both parties. It's not just some credit card statement that's a PDF. It's an agreement. It has to have an offer and acceptance, and executed by both sides. So the question is that you pose, well, what if you don't get that? Well, if you don't get that, then they better have cease and desist collection. If they haven't done that, then you may have a problem, because they should have responded. They don't have to, but they should have responded to say, well, we don't have to comply with your GB because you're beyond the 30 days. And so if you're in a situation where you've requested verification or validation and you hear nothing but the credit reporting, consumer reporting, and the collection efforts continue, then there's such a thing as a GB letter 2, where you follow up and say, you're violating me because I requested this verification, you haven't provided it, you continue to collect, and you're just trying to stimulate the debt collector to provide their legal position. So you have to be real strong. And if you still don't hear anything, then you are sort of blind. And so now the consumer, if we're thinking about filing suit on an F1, we have to really take an inventory of this debt and see if there's an underlying agreement somewhere. People, debts don't come out the sky. You have to see if there's some type of underlying agreement that may have created that debt. And if so, take a look at the payments and see if the amount they're trying to collect lines up with it. If it doesn't, then you have an F1 violation, because if they're trying to collect an amount that's not provided for by the agreement, because you can have an agreement, but now the question becomes, if this is not a random debt, does that agreement and the amount they're trying to collect corroborate? Do they line up? If it doesn't, you have a violation under F1. Whether
you put in you I think it was the perfect word. You said, then you're going in blind, right? If you don't have this stuff. And so I guess that really perfectly describes the scenario I'm trying to talk through with you, because what I'm really trying to get at is, these nefarious debt collectors going to the judge, right? And saying, well, this is a frivolous suit because we have this all. We had no duty to give it to them. And so let's pause there, back up for a second, right? FDCPA is designed for what's called the least sophisticated consumer. Is that right, Brian?
Yeah.
Okay. So what that means is basically, so maybe, I'm going to tell you as a non-attorney layman, when I hear that means, okay, Congress intended this thing to be designed to protect literally out of 300 and something million Americans, the least sophisticated consumer. Like, you could think like number 340 million on a low IQ. That's what this was designed to protect. Is that a fair analogy?
Oh, absolutely.
Okay. So then, that being said, with that understanding, because ultimately, because these companies are always going to put up their defense, right? And then that's where the judge has to make a judgment based on his conscience and the law, right? So first they go back to what was the congressional intention, right? That's what the judge is supposed to look at. And so this law was intended, literally right here, to curb abusive practices. So going in blind, let's talk about that. So you're after GB, but you send in, the equivalent of the GB, and then you send in the Brian Ponder trademarked GB follow-up. And you say, hey guys, I'm really trying to just figure this out. And then they've got the copy of the contract pasted up, taped up on the wall on their end, but they refuse to give it to you. And then they go to you and you're like, well, okay, you've sent multiple disputes and in writing, and they've not sent you anything at all that would show an original contract. And so we believe that's an unfair collection method, and then you sue them for GB, and then the judge is like, and then let's say they prove, okay, well, GB, here was the letter from a year ago. So they prove GB, but still you're going to plead all these other things, like F1 and some other things. But they're like, Your Honor, we've got the contract right here, and everything adds up to the freaking penny, Your Honor. We had no duty. We could just keep on keeping the client blind, right? That's what they tell the judge. Would it be an absolutely egregious ruling for the judge to say, hey, you know what, Brian, summary judgment in favor of debt collector, and your client has to pay their fees because they were able to proof it up now, even though the multiple times your consumer asked them to proof it up, since it was after the 30 days, they had no duty and they didn't, and that's okay. Would that be like an egregious ruling, an unconscionable ruling if that happened? That's what I'm trying to think through here from your position, trying to plead one of these things and the pitfalls that you may be up against.
Yeah. So would it be egregious? I mean, if they can prove their case, then they can win the debt collector. But again, the blindness comes in with the consumer not being able to locate that GA notice to know whether or not they are within the GB period. So the scenario I gave you earlier was the consumer did not recollect the notice, or they recollected an initial communication but could not recollect whether or not it had the GA elements in it. Now, if the consumer has on their desk here that initial communication and looks and knows it has a GA notice, or they recollects that they received a letter and it had those GA elements, and files a suit under GB, knowing that they requested verification outside of 30 days. Now that's frivolous. But what we described earlier,
right,
where the consumer does not recollect, they're not sophisticated, they don't keep and scan everything, they don't recall, they honestly don't recall, and they think that they are within their rights to request this verification, then that's not frivolous. They have a reasonable basis for their request and argument, so that's not frivolous. Under the F1, if the consumer does not have an agreement that supports what they're trying to collect and was asking for it, and the debt collector in the lawsuit produces it and everything lines up, then that debt collector can succeed out of violating F1 if they can prove that they're collecting an amount that's expressly authorized by an agreement or law. So, and that's a good point you make, because debt collectors think just because they win, everything is frivolous, and it's not. I just described to you two different scenarios where you go in blind, but it's not frivolous. But you can go in another way, and it could be frivolous if you're lying, and that's something we have to get into too. You can never lie and say you didn't receive something, because it will come to bite you. That's when you start dealing with frivolous lawsuits, and you can be charged. The consumer can have to pay fees. So you never want to go in thinking you're going to fool the court or fool your attorney. You want to be forthcoming at all times.
So that's all making sense. So let's drill in a little bit more, because this is what I love about talking with lawyers, because you guys are lawyers. And he who controls the meaning of the words controls the people who rely on those words, right, Brian? So this little paragraph right here says nothing about contracts or anything. And this really, although this is saying what a debt collector may not do, this really is providing a protection to the consumer. I mean, it's saying the consumer is protected from unfair and unconscionable means, just in general, like period, do not pass go. Okay. But then they're saying really more to protect the debt collector. Okay. If the debt collector is collecting, I mean, I'm flipping the words, but basically if the debt collector is collecting this exact amount, then they can hang their hat on that in front of the judge and say, look, we do have the contract, and 1 + 1 = 2. But let's take this out of the equation and talk about that same going in blind scenario. Okay, so from the consumer's position, so let's say again, you file the suit, they proof up the GA letter was a year ago, so your GB claim is now found to be invalid because it's beyond the deadline. They do have the contract with the client's signature that they've been holding on to secretly, and they proof that thing up. But I still feel, and this is where maybe, are there precedents on this? How do you do that? Because I feel like it all comes back to just this general catch-all right up here, right? So I still feel as though the consumer should be able to say, Your Honor, it's even more unfair. It's actually unconscionable now if they had that proof and my client asked for it two or three times and they refused to give it to my client. And so, Your Honor, like the debt collector's hanging their hat on this. But we got into this whole mess because of this. My client, before they write a check, they want to at least just see the contract and do the math themselves. Mm-hmm. So how do you cross those two things right there where the debt collector's, leaning on F1 saying, here's the contract. And then you're like, well, that's even worse, Your Honor. That's unconscionable because literally if they had it, that's what my client had been asking for. Mm-hmm. So for the debt collector now to get, to win this thing, that's exactly the spirit of why Congress created this, Your Honor, is for them to not hold on to that and operate in mysterious secrecy. So what are your thoughts? Is that how you argue these things, or how do those things kind of work together in your opinion?
I've never thought of it like that, and I probably would not argue that the fact that they had an agreement and did not produce it because they didn't have to under GB, that was unfair or unconscionable. That's not something I necessarily at first blush would adopt as unfair and unconscionable because they don't have an affirmative duty because you could to do it. And I think that with GB being very specific about when they have to do it protects them from it being deemed unfair and unconscionable when their duty to do just that is already provided for in the validation, GB section. So, but that's an argument that others, I don't know, I haven't seen that, but I do agree with you. It does seem sort of unfair when you have a unsophisticated consumer just trying their best to figure this thing out, and you're holding back information that could help the consumer resolve it. But from a legal perspective, I think that it's questionable whether the court would agree with your thoughts there. I haven't.
So yeah, no, that's why we have these things, is because you've got to feel the temperature of what the court's going to do, and then we, CROs, consumer advocates, and consumers themselves watching this are just like, I feel like I'm being railroaded, right? And you're the one that has to figure out whether to take this. So let's talk about that. That's a good segue into that. So, I mean, consumers come to you, so I guess at the end of the day, then how do you ultimately, because you'll never know probably if GB is really a valid claim until you go into it. So
I wouldn't say never. Some people, as soon as they get something, they contact lawyers. So I wouldn't say never. A lot of consumers may act very promptly in trying to deal with something. And so there are many cases where people, get dunning letters or something pops up on their credit and they act fast, and there's no question. And they may already have my GB letter, from either being a CRO or just an educated consumer, and strike timely under GB. I see a lot of that.
Okay, and so if somebody comes to you that's not striking timely, let's say, or you can't prove that they're striking timely, what are some of the low-hanging fruits for you to not want to take that, I guess, since you're not 100% confident at that point whether GB will stick or not? What do you look for, and what do you not like in those particular types of referrals?
Well, the interview consists of trying to understand, the underlying debt. Is this a debt that you had with a creditor? Okay. If yes, okay. All right. Well, let's look at the amount. Does this amount match up to your accounting of what's due? If it doesn't, then let's look at maybe the underlying agreement, because it may provide for collection fees and costs and things to add to it. So it's an interview to where you collect as much information as possible so that you can figure out what the attack is. Now, after that interview, almost no matter what is said, the first bullet you want to put out is, guess what? A GB letter. So now, whether you want to sue, because the GB letter can likely, kill and cure the situation. The debt collector may jump out of the situation and just delete it and just not want to deal with it. So, but as far as taking a case, yeah, it's an extensive interview where we have to figure out if there's a violation. And even if there's not a violation, we're still going to probably attack it from a GB perspective, either from the consumer, or if I'm retained, I may come with a GB from my law firm attacking it similarly, from as the person's lawyer.
All right, so let's shift gears to 1692E, false or misleading representation. So a debt collector may not use any false, deceptive, or misleading representations in the collection of a debt. So now here's going back to the prior example where they've got the signed contract taped right up there in front of the debt collector guy's wall. Now, if the consumer were to call the debt collector on a recorded call, if it's disclosed, if it's a required disclosure state, and say, hey, do you have a copy of my signed contract? And then they're like, we don't need to give you that, or we don't have that, or whatever, and it's literally right there. That could be problematic for the debt collector. I mean, these are things that the consumer could do potentially if it's a little hairy to get some more leverage. Yes, or am I traveling down the wrong track there as well?
Well, I mean, I think it's similar to what you just said before. I've never thought of that, and with it being
Warren Maxwell down here,
nobody's going to attack Steven.
I tell you, Warren, who invited you to the party, man? But I'm glad you brought the party favors here. Come on.
Yeah, I see what you're saying, and your thoughts may have been developed in the case before. I just haven't seen it yet, but I think it's if you ask them if they have something and they say they don't know, or they do and they actually don't, well, that's false. That's a false representation, like you're seeing. So it could be an F violation. Yeah. So again, just because they don't have to give it to you, but if they say something that's false and trying to collect that debt, like for example, what if they say they have an agreement and they really don't?
Right.
So that's false. Exactly. So I think you're on the right track in saying it's F1. But if they say we don't have to give that to you, that's different from lying about it, because they made it different. I have to give it under GP. So
all right. So let's go down to E8. This is so again, if you guys are watching this and you're trying to get your like little cheat sheet on things that you should do with your clients. So number one, send them.
E2 and E8 are the most popular.
All right, let's go up here to E2.
So they're all great, but you can look at those too.
Okay, so the false representation of the character, amount, or legal status of the debt. So, again, so if you the consumer is on a phone call with them and they can ask basic things like, what's your statute of limitations? If they're like, I don't know, or which state is this governed by? I don't know right now. Somebody over at the debt collector needs to be able to figure out basic things. I mean, like, how do I even know if they can legally collect if they can't even tell me statute of limitations? Are these like fair questions if a consumer is talking to a debt collector, or am I even just overthinking it? Like how do you take this angle right here?
Well, what you're discussing is, I don't think a F2 situation, but yeah, all those questions are fair. But if the debt collector really doesn't know, then there's no violation. If they don't know some of those, they may not know what the statute of limitations is. They should know whether it's up or not. And actually, it may be a violation if it is beyond the statute. But F2 talks about, it's sort of like a F1, the false misrepresentation of the character or amount. So the amount is, if they're trying to collect $105, saying that's what's owed under this debt when it's really $100, then they're falsely representing that $105 is owed. So that's an F2 violation, or the legal status of it. They're saying this debt legal status is, like you had mentioned, statute of limitations, that's still collectible and can be sued on if they say that it's within the statute and it's really not, then that's a status, that's a collectible.
So what would a consumer look at to see, they've clearly violated this. I mean, they would. So what if you're trying to get a copy of the contract and they refuse to give you the copy of the contract, and so you can't figure out, like all the terms to be able to conclude the current amount? Like, how do you work through all these issues?
Usually, the representation is the amount. A consumer may be able to figure out, for example, you see this a lot, they may have paid it already, and so they're trying to collect a full amount, or they may have paid it in part. They, being a consumer, may have paid this alleged debt in part, but this debt collector is trying to collect the full amount, saying that's what's due. Well, that's how I can determine it's an F2 violation, because my client, the consumer, has proof that they either paid it in full or paid it in part, and they're representing this amount is due. So that's an amount issue.
So kind of proof of payment. Cool. All right. So now E8, this is the big buzz in the credit repair type world, is if you dispute a debt with a debt collector and it comes back on the credit report not reflecting in dispute. Well, let's talk about that. My goodness gracious. So, I love Metro 2 being the industry standard for how to read a credit report. I mean, that tells you the data format. I mean, that's how I look at it, is that's their standard for how to report. So it's my standard for how to interpret and read the report. They have multiple different in dispute notations under Metro 2. I mean, dispute resolved, consumer disagrees. So let's talk about that actually. Like, do you get that granular? I mean, the high level would just be you dispute it with a debt collector, and 30, 45 days, I guess, whatever your time period is to kind of have a comfort level. You look at their following report, there's no notation of in dispute. So that would be a clear violation. Is that fair to say?
Yeah. And that.
How long do you like to wait?
All right. Well, good question. So the dispute notation has to be given by the debt collector to the consumer reporting agency the next time they communicate with the CRA, which is consumer reporting agency, about that consumer and that debt. Okay. So it's important that you review the consumer report to see if they see when the debt collector last updated that item, because you don't want to think that you can dispute something and wait a couple of days and pull a fresh report, consumer report. Oh, it's not marked dispute, I'm going to sue. That's not how it works. The case law, the courts have determined that the debt collectors don't have an affirmative duty to jump up and run and tell the CRA that you disputed something today. They just have to do it next time they communicate, which may be on a monthly basis.
Yeah.
So
that makes sense, because I mean, if they're not reporting anymore, then what you are seeing on the report is as of that most recent reported date, which is back in the history. So it's not painting a picture of anything in the future. Okay, but now do you get granular as far as if it does show any form of in dispute, any one of the codes, do you just not touch it? Or have you ever gone in and said, well, it shows in dispute, but it's still the wrong type of in dispute code? I mean, how can dispute be resolved if consumer disagrees? How can it be resolved? Like, because that's one of their codes. So do you just not sue at all if it says any form of in dispute, or can you make a distinction and still feel comfortable with the E8 violation?
Yeah, well, yeah, dispute resolve, I do have a problem with. That's not correct. But let's go back a little bit. You could still have a E8 violation pre-dispute and pre-dispute notation, because remember, E8 says communicating to any person credit information which is known or should be known as false. So if you have a consumer that's confident that the amount that's on the consumer report is false and they should know it, the debt collector should know it again, because payment history with the original creditor reflects it. So they should have, looked at these payments to make sure that everything that's being collected is actually due. So you can have an E8 violation outside of a dispute at all. So you can have not disputed it at all. It pops up on your credit, and the debt collector should have known this to be false. like the original creditor. So you have an E8. But regarding what you're asking about the different codes, I don't look at codes. If it says it's disputed, then my E8 attack I won't parse codes unless it says dispute resolved. I won't really parse codes, but my confidence would be in the fact that the information that you're given to the CRAs is false, and you should know it. So my E8 is based on the information provided, and not necessarily about the dispute or the dispute code.
So I think, really kind of the takeaway for all this, for those of you watching, whether you're a consumer or a consumer advisor of some sort, there's a number of ways to kind of weave together the different parts of the FDCPA. Probably before you send the average client over to go see you, Brian, right? So first, just send a regular GB type dispute, disputing the debt itself, not just asking for the address, and see what comes back. And during that period of time, or before they've replied, if you can make a notice of whether they stopped the reporting or not, that would be important for at least some of the circuits, and not necessarily all of them, though. And if they don't respond with that proof, but then then send a follow-up letter, just saying, follow-up dispute, saying, hey, like, I just want to re-ask you for this stuff because I asked you for it and I really want to know what's going on. And then they may send you something, they may not send you anything. Assuming you get something, then you want to try to compare those notes with, I guess, what's on the credit report, what your internal notes are, and see if there's some sort of inconsistency with the dollar amount, right? Because then that could tie to the F1, which would be just the collecting on an amount that they can't substantiate. And then you've got E2 and then E8 here. So your E2 would be, that would kind of tie to F1, would it not? In a roundabout way?
Yeah. F1 and E2 is very similar because they're, F1 is saying that amount is not substantiated by an agreement or law, and F2 is saying it's a false representation of the amount. So if you have an F1, you should be doing it at a E2, I believe. And if you have a consumer reporting, you should be looking at E8.
And then, so an E8 would be false credit reporting, whether it's not showing it as in dispute, whether showing dispute resolved when it's not, whether reporting the wrong amount in there. So these are all, if we were to say that, kind of like, what are the Cliff Notes, the checklist, would that be the high levels of the checklist for somebody to want to refer a consumer, or for a consumer directly to reach out to you?
Yeah, I mean, you can reach out to me anytime, but for people that are doing it themselves, it's important to pretty much just to execute a GB letter. Now, there's a generic GB letter, and there are some targeted GB letters. So the generic GB letter is one that can be done for any collection. Okay. Some targeted GB letters are when you're dealing with collections that deal with credit card debt, medical debt, apartment debt, student loan debt, because your verification requests can include some things that, so for example, an apartment GB can ask for some things that a medical GB doesn't, but the important takeaway is definitely get a GB letter out there. And if it's generic, fine. But if you have a more targeted letter, that's even better. One of my four steps for better credit is the last step is to lawyer up, but that can be done at any time. So if you're educated enough to know how to execute and send this letter, you can do it yourself. You see a book back there, 4 Steps to Better Credit. It has that letter in it where you just plug in basic information and you can send it out there, and that's fine.
Plug and play.
Yeah,
I've got your book.
Yeah,
I've also got your book. It's amazing. And so, hard to believe we've been doing almost a little over an hour. Time flies when we're having fun, when we're talking about the bad guys, Brian. How can the viewing audience get in touch with you?
Well, if you can, I don't know if Walmart, but if you can get a bat signal and just put up in the sky, I may see that if you want to do that. send a back signal, or you can go to brianponder.com, my website, and if you want to schedule an appointment, if you have a legal question, you can do that right on my website. On Instagram, at Brian L. Ponder, that's what you see there. Let's see, how can I point to it? There we go.
You got to point the right direction. There we go.
And on there, you can actually schedule a call with me. We can do it video, or we can do it by phone and have a consultation, and you can get specific information discussed about your matter. And also on that link tree, I have what's called a 40. Right now, I put together a 45 template package. It's 45 templates. It includes the GB letter we discussed, and the letters we haven't discussed include letters that are non-collection. And then it includes some templates with some basic lawsuits on both sides, FDCP, FCRA. But it's 45 templates, and they're all packaged together where you can download them under $10 each. So it's a nice package. It's something I put together for my 45th birthday. So
there you go. Your 45th birthday. That's in about 10 years, right? So
thank you.
On that note, Brian, it is always a pleasure going live with you. We need to try to do it more frequently, like every 3 years or something. Let's see what we have for you guys.
Absolutely.
We've got very awesome training. Thank you. That is why we do this, man. We love you guys. Thank you all for the class participation. And so go to brianponder.com. Also, feel free to go to stephenpalmieri.com. We all love you. And that being said, you all be good. We will see all of you on our next show. You all take care.